Namaskar. I am Dr. Nalini Avinash Wagmare, working as an associate professor at Tirag Maharashtra Vidyapeeth. Today's our topic is related to Government of India Act of 1935. We have to study in this act related its what were the causes to introduce of this act, merits of this act, and defects of this act, a summary and some reference books. So what were the causes? Why the Britishers introduced this act to Indians? What were the reasons? First, the Indians were not satisfied with the reforms of 1990 and they were agitating for self-government. The Simon Commission was boycotted by them and three round tables conference brought no fruitful results. But after these conferences, the British government issued a white paper in March 1933 which gave details of the new reforms to be introduced in India. So we find that the high nationalism arose in this period in 1935. The non-cooperation movement after civil disobedience movement as well Simon Go Back movement also started. But even three round table conferences took. There also the the Indians not got any fruit. So now the Indians wanted to freedom from the British rule. In that critical situation, the Britishers introduced this act to Indians. A select committee of the British Parliament deliberated the proposals given in the white paper and made certain changes in it. A bill was then introduced in February 1935 in the Parliament, which was passed in August and became in the Government of India Act 1935. Then the Government of India Act is considered as the second landmark enactment of the journey of forming a full responsible government. The Government of India Act 1935 is regarded a detailed and complicated legislation having 321 sections with 10 schedules. The Act 1935 proposed the establishment of Diarcade Center and it abolished the hierarchy in provinces. Because in previous act, in 1919 act, hierarchy only in provinces, but this act introduced the hierarchy in center, that is through this act. However, the provincial autonomy and all India federation were the special features of this act. Then what were the salient features of this Government of India Act 1935? Abolition of provincial diarchy, introduction of diarchy at the center, abolition of Indian councils, and introduction of advisory body in its place. This act provided for the first time the establishment of Public Service Commission in India. The act, besides proposing changes in the home government, suggested two following changes in the administration of India. Like a federal government would be established in India, which would include native states as well. The type of government which was established in the provinces by the Act of 1919 would be established at the center. The provinces would be given complete autonomy to govern themselves. The administrative subjects were divided into following three heads of this purpose, like the federal list, which included the subjects assigned to the central government, the provincial list, which included the subjects assigned to the provinces, the concurrent list, which included the subjects assigned both to the center and the provinces for the purpose of legislation and execution. However, it was made clear that an act of provinces would not be implemented to the extent it would contradict any act of the central government on the same subject. The provinces were given autonomy to legislature and govern matters concerning subjects given in the provincial list. The central government was not expected to interfere in the affairs of the provinces in normal circumstances. Besides, there remained no councillors in the provinces. The governors were expected to rule with the help and advice of Indian ministers chosen from among the members of the provincial legislatures. The Act thus established the system of administration which has been called the provincial autonomy. In this act also, a federal court was established at the center. The Reserve Bank of India was established. Burma and Aden were separated from India. Two new provinces, Sindh and Orissa, were created, and a full governor was nominated for the provinces of Northwest Frontier provinces. Establishment of Federal Court. At the time, establishment of Federal Court was equivalent to the today's Supreme Court at New Delhi. According to historical record, the first Supreme Court of India was situated at Calcutta by introducing the Act of 1773, which was constituted by the Britishers. The Federal Court was composed of one Chief Justice and the maximum number of 6 and other judges. The Federal Court had 3 jurisdictions, namely original jurisdiction, appellate jurisdiction, and advisory jurisdiction. In original jurisdiction, the Federal Court had original jurisdiction in any dispute concerning the Federation and its rights and dispute between the 2 or more units. Appellate jurisdiction, the Federal Court was empowered to entertain appeals arising from the judges of any High Court in India if the High Court certified that the case involved a substantial questioning of law as to interpretation of the existing provinces of the Government of India Act 1935. However, from the decision of the Federal Court, the appeal could be preferred before the Privy Council. Advisory jurisdiction, the governor was competent to seek opinion of the Federal Court while making reference of the question involving interpretation of law. Then formation of the resignation of ministers. It is to be noted that all political parties of India remarkably criticized the various provisions of the Government of India Act 1935. Though the Act was enforced in the provinces in April 1937, the central government continued to be governed by the Government of India Act 1919. However, with less effective amendments therein, at provincial levels, election was held and the Congress secured majority in several states. Elected ministers occupied the office, but it lasted only for 2 years. During the 1939, the Second World War was declared, and without consulting Indian political parties, the British government declared India as a belligerent state in war against the Germany. In result, on the ground of participation in war, the Congress ministers submitted mass resignation in the end of the 1939 to show their protest. Then the Governor General and the governors were given certain special responsibility, that is security of the Indian Empire, safety or the honor of the British Crown, and the native rulers, fulfillment of these special responsibilities. Besides, in certain other matters, they could act according to their own discretion, according to their powers. The separate communal electoral system was continued, where it reduced both at the center and the provinces. It increased the number of the voters. So here again, there were only 3% people as voters under the Act of 1919. As provided in this Act, their number became 13% of the population. So through this Act, the Act given importance to home government, the Indian Council was abolished. In its place, a few advisors were nominated to the Secretary of State for India. Their minimum number was 3 and the maximum could be 6, not more than 6. At least half of them were to be from among those who should have served in India for at least 10 years and should not have remained outside it for more than 2 years prior to their nomination as advisors. Their period of tenure was kept as 5 years. In certain matters, with such as the services, their advice was binding on the Secretary of State for India. The Secretary of State for India was not expected to interfere in those matters which the governor dealt with the help of Indian ministers. The High Commissioner for India was to be appointed by the Governor General for a period of 5 years. Then the federal government, the Governor General remained the head of the central administration and enjoyed wide powers concerning administration, legislation, and finance. No financial bill could be placed in the central legislature without his consent. He had extensive powers concerning his special responsibilities. He had the power to frame ordinances, and in certain matters, he could act in his own discretion. Then federal government under the Act of 1935 divided the federal subject into two parts, the reserves and transfer subjects. In 1919 Act also we find this type of division of subjects. He administered the reserve subjects with the help of his executive councillors and the transfer subjects with the help of Indian ministers chosen from the legislature. Thus, the executive at the center was divided into two parts, the Governor General in Council and the Governor General and his Indian minister. This meant the establishment of diarchy at the center. The federal legislature consists of two houses, that is the Council of the State and the Federal Assembly. The upper house, that is Council of State, was to consist of 260 members. Among them, 156 were to be elected from the British provinces and 104 were to come from native states. The representatives of native states were to be nominated by their respective rulers. The lower house, the Federal Assembly, was to consist of 375 members. Then among them, 250 were to be elected by the members of the legislature of the British provinces, while 125 were to be nominated by rulers of their respective states. The Council of the State was a permanent body. However, 1/3 of its members retired every year. The tenure of the Federal Assembly was 5 years. Legally, the central legislature could frame any law for India, but in fact, its powers were limited. The Governor General could refuse its advice, could frame ordinance, and the legislature had no power over 3/4 part of the budget. Then provincial government, the head of the administration of provinces was the governor. He was assisted in his task by a council of ministers who were to be chosen by him from among the members of the provincial legislature and were responsible to it. Legally, it meant that the Act of 1935 established responsible government in the British provinces. As the central government and the home government were not expected to interfere in the provincial affairs, particularly when the governor and his ministers were in agreement with one another. The newly established system was called the provincial autonomy, but in fact it was not so. Only nominally they have mentioned that. The governor enjoyed extensive powers concerning his special responsibilities. He was empowered to frame ordinances and could act in his own discretion. In emergencies, the governor could take the entire administration of the provinces in his own hands. The composition of provincial legislature varied from provinces to provinces. The legislatures of Madras, Mumbai, Bengal, Uttar Pradesh, Bihar, and Assam consist of two houses, the Legislative Council and the Legislative Assembly. In rest of the provinces, there was only one house called the Legislative Assembly. The members of the Legislative Assembly are all elected, but some members were nominated by the governors in the upper house, that is Legislative Council, wherever it existed. The number of the members of legislative assemblies and also those of the legislative councils differ from provinces to provinces on the basis of its population. The legislature could bring about changes in the budget, though of course the governor could restore it as it was. It was empowered to frame laws on all subjects included in the provincial list the question the ministers concerning their acts and could force them to resign by passing a vote of no confidence against them. In practice, its rights, however, were limited by the rights of the governor to frame ordinances, to act in his own discretion, and to act for the fulfillment of his special responsibilities. Then in provisional government, the legislature could bring about changes in the budget. So, of course, the governor could restore it as it was. It was empowered to frame laws on all subjects included in the provisional list, question of the ministers concerning their acts, and could force them to resign by passing a vote of no confidence against them. In practice, its rights, however, were limited by the rights of the governor to frame ordinance, to act in his own discretion, and to act for fulfillment of his special responsibilities. Then, what were the defects of this act? The power of the legislature and ministers were limited by the powers of the governor general and the governors. In the provinces, though all affairs one handed over to Indian ministers, yet they had no means to force the governor to act according to their desires, in case their view differed from that of the governor. Thus, the provincial autonomy was only in name. In it, the Indians were not given independent powers even in a limited field. Only namely they have stated. The communal defect, other defects are the communal electoral system exists as before much against the wishes of the majority of Indian people, because the provision of the nomination of members as representatives of native states in both the houses of central legislative by their respective rulers was most democratic procedure and was condemned by all political parties in India. The prominent political parties of India, like All India Congress in the Muslim League and the native rulers, as well as refused to accept the federal scheme at the center because of certain reasons of their own. Therefore, the implementation of central structure of this act was defective one. But the experiment was not destined to prolong for long. The beginning of Second World War brought its loom. India was made a party to the war by Governor General without consulting Indian ministers. The Congress ministers therefore resigned in protest. In other provinces, the ministers mostly worked as tools of the government. Thus, within 2 years, the working of the provincial autonomy virtually came to an end. So the minister did useful work in their respective provinces in several fields, particularly the All India Congress chose to act independently and their ministers refused to toy the line suggested by the governors. Therefore, they took initiative in certain fields like prohibition, exhibition, education, cottage industries, rural development, etc. The formation of Indian ministries proved useful in other ways as well. Political prisoners were let off and an era of terror was put to an end. The Indian leaders gained useful experience of administration and the working of parliamentary government. It also made them self-confident about themselves and inspired them further to gain independence. Thus, the merit of this acts, as mentioned above, thus the experiment of provincial autonomy under the Act of 1935 definitely served some useful purposes. Then merits of this act, the act played a key role in the drafting of the Constitution of India in 1950. A significant chunk of the Constitution, particularly the administrative provisions, were borrowed from the Act of 1935. That is the one merit of this Act. This had led to charges made in the Constituent Assembly about the Constitution being foreign and unoriginal. These types of attacks are often made even today. So in conclusion, we can say that the first attempt to offer the autonomy of the provinces was the Government of India in 1935. Women's growth in the decision-making process benefited from the separate electorates. How the Sikhs, Muslims, others are get the separate electorates through this act, women also involved in the elected system. So this act also proposed the formation of federal government, which would allow princes to participate in Indian political affairs. The new act gave the governors and governor general far-reaching powers of discretion. The act lacked a suitable federal structure, leaving the governor general in charge of the majority of the power. The Government of India Act converted the government form of India into a federal form. The powers of the central and state were separated, and the state would run under the central government. So, through this act, the central government, state government, district government, village government system introduced, and their subjects also distributed, and administrative, executive things also distributed. So that is the what we merit of this act. So in this act, we have studied the causes to introduction of this act, merits, demerits, and summary. So you can refer for more details. You can refer for these books, which is helpful to detailed study of this act. Thank you.